I will just go for a quick round of introduction for CS Rahul Padmakar, although you have the profiles with you. He is a company secretary and postgraduate in commerce. He has worked with most of the valued companies in the world, and he was a member of the board of studies, St. Louis College. He was a member of the University of Mumbai as well. He authored some weekly column, Money Plant, which is being published from Thane. And he is currently the chairman of the Thane chapter of WIFC of ICSI. So with this, ladies and gentlemen, I would request CS Rahul to please start his session. And as you have...
Good afternoon to all of you. I think the session is being recorded, so I'll be gentle while speaking on company law. In spite of the fact that I'm not very happy with the legislation because these legislations are getting amended in bits and pieces, and I really don't know whether those amendments are constitutionally valid or not. But if anybody or any company, any corporate, any professional is aggrieved by these amendments, definitely a PIL can be filed, and probability is more that the PIL will be accepted and the amendments would be quashed, because the recent amendments, few exemptions were given to private companies and Section 8 companies, even government companies. These amendments, I feel, especially to private companies, puts all our professional friends, and including our profession, mainly CA, CS or ICWA, CMA, sorry. It puts all of us in soup, because 1 year before, what we are telling our clients that you cannot do A, B and C things, suddenly those things have become legalized, and I don't know, after 1 year, may the whole act may be changed, because the company law committee has been formed, and presidents of all the 3 institutes are one of the committee members. So this is probably the only legislation could be in the world that the government thought it fit that it should be reviewed. And we are fortunate that with the same haste, government did not come out with direct tax code. And I don't see any that code is coming into reality, because if in the same haphazard manner that code also is implemented, then God will help Indian economy. See, we had a very wonderful experience with the UK Companies Act. When UK Companies Act similarly was, there was altogether new legislation in United Kingdom. 1 year gestation period was given to the UK companies, and they were told right upfront that on so and so particular day after 1 year, this legislation will come into picture. But here in India, suddenly on one fine day, the act was passed. And it was decided that the act will be implemented from 1st of April 2014. The act was implemented, but there were no rules to it. So all corporates in India for 2 or 3 days, they were all in non-compliance of Companies Act 2013. So we all are non-compliant. All Indian corporates are non-compliant for 3 days because there were no rules. And few of the sections in company law are so funnily drafted that frankly speaking, those were just copy pasted, and this legislation is what I can say, drafted in fragmented form. Like say you draft a chapter, somebody has drafted chapter number 2, somebody has drafted chapter number 3. So the whole legislation is not in sync, and it was just a copy paste. A few of the sections are just a copy pasting of earlier section and earlier 1956 section, but those are misfit. Sections are misfit. Few of the sections are giving exception to whole Company Act, like typical loan given to director, section I think 185 and 186. 186 totally negates provisions of section 185 because it starts with the word notwithstanding whatever stated in the section. The section cannot start with notwithstanding whatever contained in the act. So it means that section is a super section to company law. So that ideally shouldn't happen. Maybe I will focus today's discussion on these 3 topics, that is writing board's report, share capital and debenture, and dividend. We all know that due to joint stock form of organizations, the owners of the shares need not be into the management. So whatever management have taken decisions, whatever way management have run the company in a financial year. So management is supposed to present its report. And that report is called as nothing but a board's report or director's report. Typically, annual report consists of these three things. One is annual financial statement along with auditor's report. I am not the right person to speak on this, the first section because you are more learned than me to speak on that. I'll concentrate on the boards and directors report, and I don't have mandate to speak on secretarial audit report. So I'll stick to boards or directors report. This is the standard definition given. It says there is evidence of steady erosion in trust established for established authorities. As trust diminishes, so increases the demand for transparency. And the day the legislators drafted corporate governance code, that's the end of literal governance in India. Because when you start writing the governance standards, the tick box job or say yes no job started, and we all know that how that corporate governance report is prepared, and it's a yes no job. Typically, governance cannot be defined in whether it is yes or no. It has to come from the heart. Any kind of compliance, I would say, can be divided into 4 parts. I call it as compliance quadrant. The first compliance quadrant is Ram quadrant, Shri Ram quadrant. Shri Ram throughout his life always did what is legal and what is right. So we have to follow Ram quadrant always in our life. The second quadrant is Krishna quadrant, Sri Krishna quadrant. He always did what is right, that may not be legal. The third quadrant is Duryodhan quadrant. He always did what is legal, that may not be right. And the last quadrant is Ravan quadrant. He always did what is illegal, what is not legal, and what is not right. So we as a professionals have to ensure that our employers or our clients should never fall below Krishna quadrant. Why Krishna quadrant? Because in company law there are various sections which legally it is not possible to comply with. But you have to see to it that the spirit of legislation is respected, and this is in a way it's a very wonderful legislation. This legislation is one of the most dynamic legislations. However, badly it was drafted, but it's a very dynamic legislation. It's a rule-based legislation. The another legislation we have, rule-based legislation, is income tax and FEMA. So these acts change every now and then. So it also helps professionals, because unless and until there is a professional conduit, the corporate world will not understand what is this legislation all about. So it helps us, a dynamic legislation helps us, because we always are required to interpret. Otherwise, if it is drafted very simply, then everybody will understand there is no job left for us. So it's one of the very dynamic legislation. Let us come to what is a board report. It's a document presented before the shareholders reporting on company's condition. Very importantly, it is attached to and not annexed to financial statements. The basic difference is attached to means whenever financial statements are presented before any stakeholders, may it be shareholders, may it be government, then this report has to be attached. However, if you are giving it to any non-stakeholders, like say there is a broking entity and one of their client wants financial report of a broker. Even if you don't attach your director's report, that is okay, because it is attached to the board of directors. It is attached to financial statement. When it becomes annexure, that annexure makes that document compulsory to be attached to that document, so as to make that document a full document. So board of directors report has to be given only to stakeholders of the company, because it is attached to the financial statement. It is an inalienable part of annual report. Unless and until you give director's report to the shareholder, they will not understand what the financial statement is all about. The report includes summary of initiatives, activities of the board, personal perspective of the company's future, and it is also known as director's report. These are general rules. It is prepared based on standalone financial statement of the company. Separate section on performance and financial position of its subsidiary, joint venture companies and associate company. And very importantly, it has to be signed by either the chairman. If the company does not have chairman, then two directors who have been authorized in the board meeting to sign that director's report. One of them has to be compulsorily managing director. If a company does not have managing director, in that circumstance, any two directors of the company can sign director's report, but both of them has to be compulsorily authorized. These are the disclosure requirements under Companies Act. I have segregated it in Companies Act, Listing Agreement, and any other legislation. Section 134, subsection 3 of Company Law and Rule 8 of Companies Act, account rules. These are the pertinent sections and pertinent rules governing director's report. Let us see contents one by one. 134 section and subsection 3 of that section states that annual report provided under section 92(3), an annual report has to be filed. Every company is required to file an annual report with the ROC, and that annual report, extract of that annual report is prescribed under MGT 9. That is an extract of annual report. That extract has to be part of the director's report, and these are the contents. Importantly, I will touch upon its registration and other details, principal business of the company, particulars of holding and subsidiary company, list of holding and subsidiary company rather, shareholding pattern. Most importantly, shareholding pattern has to be even if you follow clause 35 shareholding pattern in case of a listed company, even that will suffice the purpose. It has to be categorized into category-wise shareholding, promoter, non-promoter, foreign, Indian, shareholding of promoter, change in promoter shareholding, shareholding pattern of top 10 shareholders, percentage-wise, number-wise, it doesn't matter, and shareholding of directors and key managerial personnel. Indebtedness of the company. If the company had taken any secured loan, then that would come under indebtedness. Remuneration of directors and KMPs. Penalties, punishment, compounding of offences. So penalty can be penalty under any of the corporate law. I'll touch upon this after a few more slides. The report should also contain the number of meetings of board of directors held in the year. Just to sum up, every company is required to conduct, every company that is other than 1% company is required to have 4 meetings in a year. 1 meeting per quarter has to be held, and the gap between 2 board meetings cannot be more than 120 days. The report should also consist of director's responsibility statement. Earlier section 217 2AA. Two more points have been added here. In the director responsibility statement, the director has to confirm that all the applicable accounting standards have been followed, and the policies, accounting policies of the company are consistently followed, and there is no sudden change in accounting policies. The management have taken proper and sufficient care for accounting records, and fraud detection mechanism is there in the company. The company's accounts are drafted based on going concern basis. Point number 5 is only in respect of listed company. Every listed company is required to have internal financial control. So you need to give a statement that yes, the company has internal financial control. And last but not the least, but it is very vague for professionals, practicing professionals, it is very difficult for us to identify, judge that whether a company has mechanism to ensure compliances of all the applicable laws, because in India applicable laws, in Kolkata it may be different, in Mumbai it may be different, if you go to Chennai it could be different, because even local laws would be applicable to the corporates. And even one line has been added in secretarial audit report also, that the company has complied with all the applicable laws, and huge discomfort has been expressed by ICSI that how can somebody claim that company has complied with all the applicable laws, because suppose if it is a bank is having hundreds of branches all across India, so local laws, nobody knows how many local laws are applicable. There is a very funny legislation in India that suppose you have a factory even if you cut a tree, there is a act regulating prevention of cutting of trees. So these kind of legislation, really you don't know how many laws are there in India. And our leader of the country, PM Prime Minister Narendra Modi has already issued an order that every day IAS officers must tell them, or bureaucrats must tell them a law, and he is ready to abolish one law per day, because there are more than, I believe, 5 to 10,000 legislations in India which are redundant. So even if those are laws of the country, those are practically not applicable, those are redundant. So it is very difficult to identify legislations. So it has been left to the management that what are the laws which are applicable to the management. It is management which has to identify that what laws are applicable to the company, and based on that they can make this statement. But we as a professional, practicing professional, it will be extremely difficult for us to identify what laws are applicable to the company. Statement of declaration given by independent director. So independent director has to give a statement. So that statement also will be, that statement would be under section 149 subsection 6, that independent director is really independent or not. Company's policy with regard to this would be applicable for listed companies, that while appointing any director, does company identify directors who are probably very close to the management of a company, or whether it is professionally, they have a professional agency to identify whether a director can be appointed. Few of the listed companies in India, like Infosys, TCS, they have this mechanism. And in fact, few of the very good listed companies were not able to identify women director, because their standards was very rigorous, and though afterwards they could find it, and few of the listed companies straight away appointed management's relatives as a women director, but few complied as a Shriram Padman and few complied as a Krishna Padman. But company must have a director's director nomination, a policy dealing with directors' appointment, their remuneration, and to decide whether a director is really qualified or not. So it's like this. The way we appoint employee of a company, similarly appointment of director, listed company must have a policy. So if in case they have a policy, the statement has to be made in director's report. And this particular provision is applicable for all the listed companies. Public company with a paid-up capital more than rupees 100 crores, public company with a turnover more than rupees 100 crores, and public company having loans, borrowing, deposits over 50 crores. All these companies must have a nomination policy, director nomination policy. In director's report, explanation and comments on every qualification and reservation on adverse remark and disclaimer made by auditors. So management has to really represent if there is any italics printed by, or italic statements made by auditor. That auditor may be a cost auditor, statutory auditor, or secretary auditor. So the statement has to be made. Particulars of loan, guarantee or investment under section 186. If the company has given it, if the company has not given it, a nil statement can be made. Particulars of contract, agreement entered into. So if a company has entered into any contract or agreement with related party, it doesn't matter whether that contract is arm's length or not at arm's length, whether it is at market rate or not at market rate. So list of all the contracts has to be presented in the director's report, and that's a really difficult job, because especially for professionals like us, because a company may not declare you what are their related parties, but still we need to check that with whatever. Of course, as a secretarial auditor, we do take a statement from the management that who are your related parties. So definitely, the statutory auditors also would be taking a statement from the management that who are the related parties, and Generally, what company does that if the transaction is falling under section 188, that is related party transaction, and there is a specific approval taken from the board, and yes, if it is a real related party transaction, the record would be maintained. But if in case, yes, there is a party with whom you have entered into contract, but there is a proper process followed, and really that party, though it's a related party, the party has you have entered, the company has entered into contract with that related party really based on merits. So that contract may not get captured in your RPT contract. So, but company has to keep in mind that any contract entered with RPT, whether it is arm's length or not arm's length, these contracts has to be categorized differently in the director's report. Also, the state of company's affairs is a very generic statement, but directors has to speak about company. Is it doing well, not well, or is it performing? Is it stepping up its performance? That statement has to be made by the management. Amount proposed to be carried out to reserves. So if management is having any earmarked reserves, what amount will be transferred to reserves? That will be mentioned. Dividend recommended, if any, is management coming out with dividend? If the dividend is declared, then the rate may also be declared in the board of directors report. And of course, management has only powers to declare the rate of dividend. It is up to the shareholders, even about reserves as well. So reserves has to be approved by shareholders, and dividend recommended also has to be approved by shareholders. But there is a difference between approvals given by shareholders. In case of reserves, which management proposes to transfer to profit and loss account, if that proposal is rejected by the shareholders, then company may have to draw its balance sheet again, because in the balance sheet the effect have already been given. But at least I have not heard that shareholders rejecting a proposal to transfer funds to reserves. But if in case if you come across any of the instance wherein shareholders are rejecting transfer of any funds to reserves, then the balance sheet has to be drawn again, because it will impact your below the line items. And of course, dividend recommended. Generally, no shareholder has till date rejected the dividend. So they may ask only if they want more dividend. Now it's a debatable point whether shareholders can ask for revision in dividend. Can dividend be higher than what is proposed by directors or not? It's a debatable point. Then also conservation of energy, technology absorption, foreign exchange earnings and outgo. This was the standard stuff in earlier act as well. So it is being carried forward. The risk management policy. The company must have a risk management policy. Previously, yes, a good corporate governed company listing agreement was making them compulsory to have risk management policy. But here now it is applicable for specified companies, and the ambit has been more. So every company must have a risk management policy. Typically, it is if the company is having huge foreign exchange earnings and outgo, they should have a hedging mechanism for that foreign exchange. So that could be risk management. Now earlier, company used to have it based on they used to hedge their foreign exchange depending on the circumstances. Now that has to be documented, and if you have a risk management policy, you need to have some committee to oversee that risk management policy. So whether that RMS risk management policy has been complied with or not. So that mechanism has to be there. And as an auditor, we'll look into that as well. That there is a document in place, but whether compliance of the document has been done or not, that generally we don't go into detail about it. But now these are the days where you can not only ask about RMS policy, but whether really the transactions which the company have done, whether it is according to your policy or not, that also will be looked into by professionals. And if there is any exception, professional call we all can take, that whether we need to report it in the director's report it in our auditor's report or not. Policy developed and implemented for corporate social responsibility. Now, any company having a paid-up capital more than any company with a net worth more than rupees 500 crore, turnover more than rupees 1000 crore and profit more than rupees 5 crore in a year has to compulsorily spend 2% of its amount into corporate social responsibility. So any company coming in this ambit has to have a CSR policy. So if the company is falling into that CSR policy provisions, CSR provisions, brief outline of the CSR policy needs to be given. Composition of CSR committee. Now CSR committee would be required. Average net profit for 3 years. Prescribed CSR expenditure. So statement wise, how much expenditure, what is the eligible amount, did company really spend it, if spent on what projects they have spent it, if not spent, then reasons for not spending the amount. So that will be there. And the lastly about a responsibility statement has to be made by CSR committee that they are committed to doing corporate social responsibility. So that statement will also be mentioned. If a company, say for example, company is supposed to spend 10 lakh rupees on CSR, but the company hadn't spent it, and company has spent say rather only 1 lakh rupees, then what is? The company only need to mention that why they failed to spend 9 lakh rupees. There is at least no penal provision for not spending it, but it is required that in the director's report you must mention that why you are unable to spend the amount. If the director's report is silent on the CSR spending, yes, in that case there is a penal provision. So spending CSR amount, though it is not obligatory, I still call it as it's a voluntary. Only thing is that if you do not spend, you need to state reasons in your director's report that why you did not spend it. So once the compliance will be done if you follow two things. Number one, you spend the amount, or you do not spend the amount, but in director's report you may simply write that I don't want to spend CSR expenditure. What matters is you must mention in your director's report that have you spent the amount or not spent the amount. Details of performance evaluation. Now this is a new thing. Every director in the company will be evaluated. Now who will evaluate? The only directors will evaluate directors. Ideally what company should do, independent director will evaluate the non-independent director and non-independent director would evaluate the independent director. But evaluation of directors and board's own performance has to be there. And it is applicable to all the listed companies and all public limited companies having paid-up capital more than 25 lakhs. So all directors of the company would be evaluated. If the company does not have evaluation policy, company must get it done. And not only the evaluation policy, the independent director who are evaluating other directors, there has to have a proper meeting, and that meeting will not be counted as it really held unless and until the minutes of the meetings are prepared. So as an auditor, we must ask that are there any minutes for evaluation of directors? Because just by having policy, it doesn't give any idea that is the evaluation really happened or not. Section 197. Now we are provisions of section 134 and rule 8 are over now. Under section 197. Every listed company shall disclose in the board report. Now this is a very new thing, and we I believe in 12th standard or even in our intermediate examination we have learned a bit of statistics so that our statistical knowledge will be tested by government. We need to give ratio of remuneration of each director to the median of employees' remuneration. So in director's report, not only will keep everybody on toes, even our HR department will ask from HR department that find out the median of remuneration of all the employees, and we'll find the ratio to that median with respect to remunerations paid to each director. Managing director and or full-time director getting commission from company may also get commission from holding or subsidiary company, provided this fact is disclosed in the director's report. Disclosure under company account rules. Let us see. It should have financial summary and highlights. So that's a pretty basic stuff which we do earlier also. That financial summary. Last year this was this much profit. This year this much profit. Then economic, then our statements related with economic policies, economic outlook, and then we'll explain whether company is doing good, bad, ugly, better, whatever it is, or best. Change in the nature of business. If there is any shift in the business which company is doing, then any change in the nature of business. Details of change in the directors and key managerial personnel. So any changes in the directors would be mentioned here. Details of deposits accepted during the year remain unpaid or unclaimed at the end of the year. So details related with deposits. Any material order passed by court or regulator affecting status or operations of the company. Recently, a very, I believe it's a Nifty company. Nifty company was pulled out by SEBI for not disclosing an income tax order, income tax notice issued on that company, and that notice was running into 350 plus crore rupees, and the company really did not bother to inform to SEBI that this is a notice, and the profits of the company, I think per year was around 200 crore rupees, and suddenly there is a notice of 350 crore rupees. So it will not only have huge impact on its share prices, but also in the profits of the company. So that company was pulled out. So any court issuing notices against the company, of course, I don't know. This doesn't mean this doesn't mean offense of a technical nature. Like say, director's driver is dumping a signal and the police officer is cutting a challan of 100 rupees. That is not an offense. That's a technical offense. So offense is having material impact on working of a company. So that should be ideally the order, or that should be ideally the offense which we are looking out for. So that offense could be any offense related with corporate laws, any offense related with economic laws, or any offense which is having bearing on working of the company. Like say, suppose there is a fire in factory and some workers died, and there was an inspection by inspectors under Factories Act. Yes, that is having bearing on company's policy. Or suppose there is a food supply chain company, and Food Drug Administration raided that premises. Suddenly it will go, their business will go for toss. So any law which is having impact on running of the company, and regulator of that registration, it passes any kind of order, that order we are looking for. And we are not looking out for an offense like say company hasn't renewed its shop act license. That's a minor offense. So merely you need to pay some penalty and get off. But those acts, no, I'm not saying those act doesn't have bearing, but those acts, those non-compliances are not having huge bearing on affairs of the company. So that could be technical offense, 1 or 2 days here and there, or say rather you would call it as company hasn't filed its balance sheet and company is paying additional penalty. There is a compounding provisions given in the act, so that really will not have an impact on company's affairs. But yes, company has accepted deposits. A non-compliance may result into imprisonment of a director. Yes, that's a non-compliance which we are looking out, and those kinds of non-compliances would be mentioned in the director's report. Disclosures under listing agreement. So these are the few clauses. Clauses I will not read out. Details of shares held in suspense account. It means in IPO or any of the following public issue, company has allotted the securities, but either DPID is wrong or the demat account number company has the allotee has mentioned wrongly. So those shares returned back. So those shares are held in suspense account. Company has to disclose on a regular basis that is there any how many shares are there in the suspense account, and company has to on a continuous basis need to look out for that who are the shareholders which are not identified, and try to establish their KYC. Once KYC is established, then suspense account shares has to be transferred into their account. But if there is any suspense account shares, that has to be recorded in the director's report. Details of shares are held in unclaimed suspense account. Again, it's a link with the earlier. Disclosures regarding related party. disclosures regarding loan advances and investments in own shares by listed companies, their subsidiaries and associates. So this disclosure also would be required. Criteria for performance evaluation. Now earlier this was not compulsory for all the listed companies, but now it is compulsory for all the listed companies to determine, not only have a policy, but to also on a regular basis check, identify that whether directors of a company are really working hard for affairs of the company. So there has to have a criteria for performance evaluation as laid down by nomination committee. Compliance with code of conduct. Every director is supposed to write code of conduct. Supposed to give a statement before the management that they will abide by code of conduct of the company. Remuneration policy and evaluation criteria. So remuneration policy, it was compulsory for earlier, compulsory under listing agreement. Now same remuneration and nomination policy will be compulsory for companies who are in the bracket of the paid up criteria, which were just in the last few slides. Policy for determining material subsidiaries. That are the companies really subsidiaries of the holding company or not. So there has to have a criteria specified. Policy for entering into related party transactions. So every company must have an RPT policy. Now that RPT policy will really determine whether company has, according to policy of the company, entered into transactions with its RPT or not. Industry structure and development, what your company, which kind of industry it is, opportunities and threats to the company and the industry, segment wise or product wise performance of the company, outlook. So this is the standard stuff which was there earlier also, and most of the companies are though it's a very vaguely drafted director's report I have seen, or we have seen, but these are the points which every company must have in its director's report. Risk and concern, internal control system and their adequacy, discussion on financial performance, material development in human resource, industrial relations fund, and including number of people employed by the company. So that will be mentioned. Details of training imparted to independent directors. It's a new requirement. Company on a regular basis must hold a training for its independent directors. So those training could be coaching them on new laws, coaching them about company's policies, or coaching them about working of the company. So that training is must now. Details and establishment of vigil mechanism. So this is to help to thwart company from committing any wrong. So company should have a vigil mechanism and whistleblowing policy. Whistleblowing policies typically mean even if, so I am from production of a company, but I can see that some person or say finance person entering into server room of the company. So finance person, there is absolutely no need for him to go to server room. So I may blow the whistle. I may complain to the management that what finance person is doing into IT server room. So in spite of being a fact that I am from production team, it is really not my job to see that what else is happening in some other department. But if I come across any wrongdoing within the company, it doesn't matter whether it pertains to my functioning or my job function or somebody else's job function. It is my duty that I must raise a voice and see to it that wrongs in the company should be stopped. So that protection will be given through whistleblowing policy of the company. Any other law. So any other law means any other law under the sun in India. I was able to find out few legislations. Section 22 of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act. It's a new law. So company must have a policy on prevention of harassment of women at a workplace, and that act requires that annual report of the board must contain number of cases filed and disposed of during the year. So this is one of the legislations wherein in the annual report this facts must be mentioned, and if annual report doesn't have this fact, then it's a non-compliance of this legislation. and this legislation is applicable to all the companies. It doesn't matter whether a company has 10 employees, 20 employees or 5,000 employees. This legislation is for all the companies, applicable to all. Suggested items, there are few suggested items. This is based on few of good corporate, their policies for the years. So based on that, these are the suggested items which may be, though it is not mandatorily required, this may also be included in the director's report. Statement on company's philosophy, board of directors, its composition, attendance by each director. Now, this is not a mandatory requirement, but it is better that just shareholders to identify whether a director is really performing well or not. So composition and category, attendance by each director, and the day on which the last annual general meeting was held, number of other boards and board committees in which a director is member or a chairman or chairperson, details of various committees, any subcommittee companies having, then composition of that subcommittee, how many meetings, the details of the meeting, means of communication, what communication mode a company follows to communicate with its shareholders. So suppose if I publish my annual report on my website, so that website address would be mentioned. If I publish in a newspapers, I may also mention names of the newspapers on which I generally publishes my quarterly results. Newspapers where the results normally gets published, any website where it is displayed, where it also displays official news release, the presentation made to institutional investors or to analysts. Listed companies generally to give idea about their workings quarterly basis or half yearly basis, even on a yearly basis, and they call meetings of institutional investors, meetings of top ranked research houses, interact with them about the policies of the company, future outlook. That communication also needs to be disclosed among the shareholders, so that shareholders, even though they are not institutional investors, they should also be informed whether to remain with the company or not. So this is one of the very good practices which corporates follow, and generally their meetings with the institutional investors are open for even for shareholders or non-shareholders. General shareholder information, date of book ledger, dividend payment date, RTA, name of the registered transfer agent, their address, if in case email has to be dropped, then the email ID as well, share transfer system, what system company is following, distribution of shareholding, what is the, then dematerialization of shares and its liquidity. So nowadays listed company, 100% listed companies are under demat mode. This is really may not be required as of now. Details of non-compliances made by the company, penalties, this has become a mandatory requirement. Earlier it was not a mandatory requirement. Penalty for non-compliance of any of these provisions. Penalties are huge. Now it runs into lakhs. For company, it is anywhere between 50,000 rupees to 25 lakhs. For officers who are responsible for making director's report, the penalties may run into 50,000 to 5 lakh rupees, and there is an imprisonment up to 3 years or both. If you have any doubt on the first part or query, I am ready to answer. Yeah, it is applicable to all the companies. Yes, all the companies must have. Where you are having, it's not, because that policy doesn't recognize that requirement. No, if you do not have women employees, then of course it is not possible. It is not applicable. Yeah, you can say that, because you don't have women employees, so no need to have women. Yeah. There was a bill. Yes. Yeah, you can say that since we do not have any women employees, we are not having committee. And about that committee also, let me tell you that committee should consist of women as a chairperson. One member has to be there who it has to be a female outside member and that female outside member must work for women empowerment through some NGO or social circles. So there will be not only your women employee will be heading the senior most women employee will be heading that committee, but also there will be an outsider to head that committee. So management really will not have any say in that committee. So it will be totally independent committee. It need not be women director. It has to be a generally senior most women employee. You won't make a sweeper as a chairman of that company. Definitely it has to be somebody who is a senior most women employee as a chairperson of that company.
No, I mean to say that there is a woman director. There is no other employee, woman employee.
Yeah.
And the remuneration is being paid to the
Women director.
That is whether the
For attending minutes, for attending meeting of
this particular section
committee. No, in that case, if she is an executive director, we don't pay any remuneration to executive director for attending committees.
she is not a remuneration, she is not a executive. She is the executive.
Yeah, that remuneration, I think it will be sitting fees. So that will come. Yeah, that will be remuneration paid to director. But generally, in the remuneration to be paid to that committee chairperson, it will be out of pocket expense. I believe it will be out of pocket expenses only. So it will be hardly anything. It's a few thousand rupees here and there. We really won't pay her 20 lakh rupees. So that will not matter a lot. But yes, that's a remuneration paid to director. Okay. Now the second part of my discussion, share capital and debenture. Section 43 to section 72 deals with shares and debentures, and companies share capital and debentures rules 2013 are the rules which govern this. Section 2 subsection 84 defines the term share as share in the share capital of a company, and it includes stock. So it's the same definition which was there in 1956 Act, and there are few case laws wherein it is defined that share is a bundle of rights and obligations. So there are rights available to shareholders, but what are their obligations? Now suppose a company has issued a share at rupees 10. The obligation of the shareholder is rupees 10 to be given to the company. So till the time the shares are not made fully paid up, there is an obligation. So that's why that obligation for shareholder will be that he is paying nominal value of the share. And if the shares are issued at premium, 10 rupees share is issued at rupees 80. So till the time shareholder doesn't pay 80 rupees for subscribing that shares, he is under obligation. So these are the obligations of a shareholder. Otherwise, all the rights available to the shareholders, right to receive dividend, right to receive communication, right to receive annual general meeting notice. So these all rights will be applicable to shareholders in the normal circumstances. Right to vote also is one of the rights given to the shareholders. Section 2 subsection 93 defines about voting rights. Now what does voting right mean? It means right of a member of a company to vote in any meeting of the company or means by postal ballot. Now the voting right will be given to the shareholders based on the number of shares he is holding. So suppose I am holding 10 shares, I will have 10 voting rights. Similarly, person holding 1 lakh shares, he will have 1 lakh voting rights. Shares can be, there are three stages of share. Share can be in any of these 3 stages. It is observed in Sri Gopal Paper Mills Limited versus CIT. Now, a share can be form of an authorized capital. A company is having authorized capital of 1 lakh rupees. Out of those 1 lakh rupees, company has issued only 10,000 shares. So there could be 90,000 shares which are yet to be unlocked by the company. Even that will be called as share of a company. So an authorized capital, that is fixed capital of a company, which is in the womb of the company, and there is no identified shareholder. Once the shareholder is identified and shares are allotted, then it becomes issued capital. It attracts section 44. You identify a person, you identify a member, you identify an entity, and you allot that shares to him, that person becomes member. So that is the second stage of the share. And the third stage of a share is shares are converted into stock. Right now in Demat era, nobody wants to convert its share into stock. So this is another redundant. Having the stock is a redundant concept now. But earlier, when the shares are held in physical form, so I am having 10 lakh shares of Reliance Industries Limited. I really don't want to hold those 1000 share certificates. So I go to company and tell the company that issue me one consolidated certificate. That consolidated certificate will be stock. The only you can say pros and cons of a stock is you get a single share, you get a single certificate, but bearer of that instrument becomes owner of the share, owner of those shares. Another pro for stock is stock can be fragmented, so even there can be a fraction of share. Suppose I am having a stock certificate, and that stock certificate signifies 9,900.5 shares. So stock can be fragmented in the fraction of 1 as well, but shares cannot be fragmented. It has to be in the multiple of 1. But in Demat era, now it really doesn't make any sense in holding stock of a company. So what you should hold is share of a company. So these are the 3 stages of shares. This is kinds of share capital. Now you are experts in knowing this, that share capital can be equity, preference, with voting rights and with differential voting rights. Now, earlier private limited companies were even allowed to issue shares with differential voting rights. Earlier means I am talking 10 years before. But now, as the law itself says, law itself allows whether whatever kind of company it is, private, public, listed, unlisted, to issue shares with differential voting rights. The fantastic example we have is Tata Motor DVR. Tata Motor DVR is much more priced as compared to Tata Motor normal shares. So that is differential voting rights shares. Let us see what is differential voting rights share in the next slide. Before that, preference share capital. Now preference share capital typically means that part of capital which carries preference rights. Those rights can be pertaining to dividend, repayment in case of winding. So preference shareholder will always get dividend before equity shareholders get their dividend, and even in case of winding up, they will get their monies first, and then the equity shareholders number will be equity shareholders money will be paid to equity shareholders. Capital shall be deemed to be preferential share capital if they are entitled to participative dividend and participative repayment of capital in case of winding up. So this is deemed preferential capital requirements. For issue of shares with differential voting rights. Now typically, suppose I own share capital, but I don't have any right. I own equity share capital, but I don't have any right to vote. That is, I am having share capital with differential rights. So differential capital can have 2 kinds of different rights as compared to directors. That is, right to vote and right to get dividend. Conditions to be complied with if a company wants to issue DVR shares. The conditions are, there has to have a provision in Articles of Association. Members' approval by way of ordinary resolution. It's not a special resolution. What you need is ordinary resolution. Such share after issue, post issue, cannot exceed 26% of the total paid up capital of the company. Company need to have 3 years profitability track record. There should not be any default in filing annual report for the annual return for the last 3 years. There should not be any default in payment of dividend, payment of matured deposits, redemption of shares, or interest or dividend on preference shares. There should not be any default on repayment of term loan from a public financial institution or state level financial institution. And company should not have defaulted in any of the economic laws or corporate laws, which includes SCHEMA, RBI Act, CB Act, etc. When a company issues differential voting right along with ordinary resolution, every company need to attach an explanatory statement, and that explanatory statement must have these following items. Those are total number of DVR to be issued, details of differential rights, whether these rights pertain to receipt of dividend, payment of dividend, or with respect to the voting rights given to the shareholders. Percentage with total capital so as to measure whether company is exceeding 26% or not. Reasons and justification for issuing shares with differential voting rights. Price and basis for the same. Existing equity capital along with voting rights. Now DVR shares and non-DVR shares cannot be interchanged. So once DVR shares are issued, they cannot be converted into full-fledged equity shareholders and vice versa. There has to have a proper disclosure in Board of Directors report that these are the DVR shares issued during the year or till date. These are the number of DVR shares which has been issued. Let us see voting rights. What are the provisions related with voting rights? Equity shareholders will have voting right with respect to any resolution which is placed before the members of the company. In case of poll, now there could be there are 4 types of voting which can take place in annual general meeting. One is voting by raising of voice vote, yes, no. Second is raising of hands. But in both these circumstances, voice vote and raising by hands, we really don't come to know that it may happen that the person who is holding 99.99% shares, he may not have raised his voice, or he may not have raised his hand. So in that circumstance, the actual voting, the actual number of shareholders who have agreed for that particular resolution doesn't come forth. So that ideally come forth when there is a postal ballot or when there is an electronic vote. In those circumstances, in postal ballot and electronic vote, the voting of the shareholder will depend upon the number of shares held by them. So in case of poll, the voting right shall be in proportion to shares held by them. Preferred shareholders has right to vote on only on those resolutions which is affecting their rights. So suppose preferred shareholder are agreed for 12% preferential dividend. But suppose tomorrow company decides to change that 12% dividend to 10% dividend. So their rights are getting affected. Preferred shareholder will get right they will get right to vote only on those resolutions which is affecting their right or which is affecting their right. However, the preferred shareholder will get full-fledged rights of an equity shareholders in 2 circumstances. Number 1, in case preferred shareholder in case a preferred shareholder is not paid dividend for exceeding 2 years, they get full-fledged rights which is available to equity shareholders. So that's the only point you may have to consider. So all preferred shareholders, if not paid dividend for 2 years, they will get the same rights which are available to equity shareholders, and all the resolutions which is put before the members, even a preferred shareholder can vote on those resolutions. Share certificate, provisions related with share certificate. This is a document which shows ownership of a company. Just by merely by possessing share certificate, a person cannot be termed as a member. So share certificate does only signifies that so and so person is owner of the share certificate. So it's merely a document. That document can be transferred, that document can be bought or it can be sold, but that document signifies the shares held by the person whose name is registered in the register of members. In case of shares which are held in depository form, the records of depository is prima facie evidence of the ownership, because if the shares are held by depository, may it be NSDL or CDSL, the name of the depositories will be there in the register of member. However, the list of beneficiary owners as recorded by depository, those are the actual shareholders of the company. So if the shares are held in depository form, the shareholder, the actual owners are called as beneficial owners, and depositories are called as registered owner. Share certificate must have distinctive number except in case of when shares are held in depository form. So demat shares doesn't have any distinctive number. Only physical shares will have distinctive number. First time the the company law has defined, the company law has prescribed the share certificate form, and that form is SH1. Share certificate is compulsorily required to be issued to shareholders within 2 months from the date of incorporation in case of subscription of memorandum of association. So if the company is formed, subscribers to the memorandum must be issued share certificate within 2 months of the incorporation of a company. If in case of any further allotment, within 2 months of allotment of shares or date of allotment, share certificate must be issued to the shareholders or members of a company. In case of transfer or transmission, within 1 month, and in case of issue of debentures, within 6 months from the issue of debentures, share certificate must be issued.
Irrespective of the companies.
Irrespective of whether it is limited or private company. Yes, it's applicable to all companies. Duplicate share certificate, issue of duplicate share certificate. It may happen that the share certificate are either lost, soiled, toned. So in that circumstance, definitely there are provisions. Earlier Act, there was no specific provision dealing with duplicate share certificate, but this Act has 2013 Act has specifically provided for it. So, but a few conditions are there. Number one, there has to have a board resolution. Now definitely the board can delegate this power to any of its subcommittee for issue of shares or duplicate share certificate. Prior approval of board of directors is required. Duplicate share certificate is required to be issued within a period of 3 months after submission of all the documents with the company. And in case of listed company, the period is 45 days. So 45 days for listed company and 3 months for any of unlisted company. There has to have a register maintained in form SH2, wherein all the records with respect to renewed and duplicate share certificate issuance will be maintained. This includes name of the shareholder, distinctive number, the number of shares which was issued, the number of shares which were earlier issued, and the duplicate share issued. So all those records will be there, kept in duplicate share register, that is form SH2. Securities premium account. You're saying there is a different company and different company is not issuing duplicate share certificate. It is activated now. It is incorporated since when? Yeah, if it is incorporated 10 years ago, they have it's a continuing offence. Then either management of a company has to go and compound the offence, or if any regulator doesn't know that this offence has been committed by the company, then just keep quiet and issue share certificate as soon as possible. Yeah, not in the new form, it has to be in the old form only. But since company has not issued it, then it's very difficult to gauge what kind of non-compliances the company has committed. But definitely it's a continuing offence by the company. And off the line, definitely we can find out the solution. The